Hello everyone, welcome to Jamaica 411. We bring you this special news item just in, hot off the press. Paula Llewellyn wins. I have not yet gone through the judgment. What I saw was a summary that the judges were so very kind to prepare for us so we can understand their ruling. And I will be reading that for you shortly. But this is certainly news. And my peeps, when I looked at the first page of the press release that this is unprecedented. This must be the first in the world, but it's an improvement. It's about transparency. And they all know that this was of very great public interest. But, it looked a little weird to me. When I looked and I saw the names, Philip Paulwell, Peter Bunting, and so on. And I said, but, this kind of look a little weird. Talk truth. I mean, Paula Llewellyn is a public servant. She's a director of public prosecution since 2008. But that's not it. She's a public servant. A constitutional body was created called the Director of Public Prosecution. And when you say two members of the political directorate going up against her, because that is how it appears. Now, yes, the argument was about the law and whether or not the government, was hustling to have her remain as a DPP. And yes, if you believe that the Constitution was breached, you need to have the matter challenged. But for me, to have members of the opposition carrying the matter to court, and when the court ruled partly in your favor, partly against you, you went and you did what is called a counter appeal, wanting another section struck down. And for me, I don't think that looks good at all. They should have at least tried to get some private sector interests, because it's something that affects us all. It's not just the politicians. So if they had gone and gotten like maybe 2 or 3 more private sector groups to join them in the suit, that now would be different. You follow? Yes. But for them, Peter Bunting and Philip Paulwell, to take the matter to court and then went and counter appeal, somehow just seeing the two of them name alone, and it no look too hot. I have to admit. My party, but no look good. But as I said, let me go and take a peek now at the ruling and see what I can find and bring it to you. What I'll probably do is bring a part of it and then read the whole of it for you later on. But you want to know what's going on, so let me just oblige. What you say to that? You agree? Great. But before I begin, I'm going to ask you all, please, my subscribers as well as those who are watching for the first time, please give the video a thumbs up from now and share please, and rejoin me. Remember, you're quite free to leave your comments in the comment section. I do appreciate it for persons who will be listening for the first time, as well as I would also appreciate if you would subscribe to the channel to help us grow. And of course, I thank you all in advance. Great. So let us now look at the Court of Appeal. There were 3 judges: Justice Straw, Justice Harris, and Justice Leng, Acting Justice Leng. So it says here the Attorney General, it was the appellant, or is the appellant. And you have now as the respondents Philip Paulwell, Peter Bunting, and they have here Paula Llewellyn as the intervener, I suppose something that concerns her. And it's a press summary. This is highly unusual. I've never seen anything like this. So it's in lieu of their full judgment, which is probably enough pages. So they are making it simple for us to follow what is happening. So the date of the delivery is today, which is December 20, 2024. And at paragraph 1, the justices went on to say, this matter involved an appeal and counter-appeal against the decision of the full court of the Supreme Court, delivered on the 19th of April 2024, whereby it struck down Section 2.2 of the Constitution, amendment of Sections 96.1 and 121.1, Act 2023, and it's to be referred to henceforth as the Amending Act, and declared Section 2.1 to be valid. So, what is this about? You recall that Philip Powell and Peter Bunting took the matter of the extension of Paula Llewellyn's extension to remain as the Director of Public Prosecution until she is, I believe it's I think it's 65, And the contention was that the Constitution only allows for one extension. Paula Llewellyn had asked for, when she attained just before she attained the age of 60, as the Constitution requires, she asked for an extension of 5 years. And Dr. Peter Phillips had objected to it when he was the leader of the opposition. But Andrew Holness clearly wanted her to stay, to give her the opportunity to continue serving. Apparently, a compromise was reached and she was only given 3 years extension. Then now she applied again just before the appointment expired. She applied again for an extension, further 2 years, I believe, extension, and that now was granted. The government went to Parliament with an amendment to Section 96.1, which affects her, and 121.1, which affects the Auditor General. And the extension basically is to allow them to be 65 years old, right? So they would serve up to 65, and then they can apply for an 5-year extension until they are 70. So they rushed it through the Parliament. The opposition, for whatever reason, is against Paula Llewellyn remaining. And therefore, they went to challenge the matter in the court. And they won, whereby the judge in that hearing, she struck down part of the law that was, Constitution that was amended, and allowed the other part. So the Attorney General appealed the part that was struck down, and the two PNP operatives, Philip Powell and Peter Bunting, appealed the part that was allowed. You're following? Yes. So now the Court of Appeal has to deal with these two appeals. And they evidently made a ruling. And what the Court of Appeal was asked to do by the Attorney General was to overturn the lower court's decision to strike out that section of the Constitution that was amended, that the court had struck out. And what Philip Powell and Peter Bunting is asking the Court of Appeal to do is to strike out the court's ruling to allow a section of the Constitution which was amended by the Labour Party's majority in the Parliament in a big rush. You got that? Great. So let me continue. So the judges went on to say the appellant, the Attorney General of Jamaica, filed a notice of appeal on 23rd April 2024, outlining 17 grounds of appeal by which he seeks to overturn the full court's decision on Section 2.2 and requesting a declaration that Section 2.2 of the amending act is a valid constitutional amendment. The first and second respondents, Messrs. Philip Paulwell and Peter Bunting, respectively, by their counter notice of appeal filed on the 29th of April 2024, challenged the full court's decision on 7 grounds and asked this court to overturn the full court's finding that Section 2.1 of the amending act is a valid constitutional amendment and affirm the full court's decision to strike down Section 2.2 of the amending act. Now, I know you might be asking, what's all this about, Michelle? What's it all about? Get to the point. Well, judges never do, but they're going to explain to us now the background to the decision that they're about to make, or at any rate they made. And therefore, you will hear now what all them amending acts hinting is. All right, great. Let's go now. So at paragraph 2, the court said, for an appreciation of the issues that were considered by this court, a summary of the background leading to the appeal will be provided. Ms. Paula Llewellyn, the incumbent Director of Public Prosecutions, the incumbent DPP, was slated to retire on the 21st of September 2020 at the age of 60 years. She requested an extension of her tenure as DPP under Section 96(1) of the Constitution, which was granted for a period of 3 years, up to age 63. The incumbent DPP subsequently sought a further extension to continue to age 65. Now remember the background I gave you? And what I didn't tell you, what I believe motivated her action, was that the government had gone in and increased the retirement age of everybody in that serving in government, right? To 65 at least. I think it's male and female about 65, right? But because the DPP and the Auditor General, they are not under ordinary law. They come under the Constitution. It was the Constitution that created those bodies. So therefore, the ordinary laws, which affected everybody else in the public service, did not apply to them. It required the parliamentarians to go into Parliament to amend the sections of the Constitution which created those jobs, right? The DPP and Auditor General, and there increase the age to 65 for them. They recognized it when they were discussing it in the Joint Select Committee. They recognized it and they did not do anything about it. So Paula is the one that was fast approaching the age of 65. The Auditor General is a bit younger. So, we don't know if she won't even serve for so long. So what I think Paula was trying to do when she asked for a 5-year extension was to allow her to have the same and be in the same position as all other government workers. So she can now retire at 65. I think that was what motivated her, right? And so she asked for 5. And because of the disagreement between the leader of the opposition and the Prime Minister was willing to grant her, and she was not. The Governor General then extended her time for 3 years. When it was up, she tried, but this time she tried to extend it for 2. And this is what suggests to me that may have been what was motivating her. She wanted to be at the same level as all other public servants, save for the blasted politicians, them slackness, right? They did not amend the Constitution, which would then allow her to be on the same footing as everybody else. You follow? Right. So let me continue now. So, of course, they said the incumbent DPP subsequently sought a further extension to continue at age 65. She was ultimately advised that a further extension would not be granted. 2 months later, the advice would come now from the Governor General, right? 2 months later, on the 25th of July, 2023, a bill enacted an act to amend the Constitution of Jamaica to provide for an increase in the retirement age of the Director of Public Prosecutions and the Auditor General, and for connected matters, the amending bill, so that's the amending bill now, was tabled and passed in the House of Representatives. So you understand what the background is. You understand what was going on here now, my peeps? Yes. When Paula went to seek the other 2 additional years, she was turned down because the Constitution is so worded that it spoke about the Director of Public Prosecution wanting an extension. Then they should an extension. Then she should request it sometime before her, I think it's a year before her 60th birthday. So the way the Constitution is worded, it appears as though it's only 1 extension that was allowed. So when she applied now for the additional 2 years, I guess the Governor General was advised by his Privy Council that it cannot be accommodated because she's only allowed 1 extension. So the government now went into Parliament thinking they have a fix and decided to amend the Constitution to allow her to serve until 65, and then she can then apply for an additional 5 years. It sounded as if it was some kind of retroactive law, and perhaps that's the reason why the lower court struck it down, but we will hear from the judges. So this was what was happening now. The government was trying to, in my view, the government was trying to correct a mistake that was made on their part in not bringing the legislation forward to have the Constitution amended that would now allow the DPP and the Auditor General to serve until they are 65, and from that point, if they want an extension, they could ask for it. And I think they were trying to rush it through the Parliament, probably their fault for not explaining it properly to the opposition. In any event, I don't think the opposition want Paula Llewellyn there. I don't know why, but that is their position. Anyhow, let us continue reading now from what the judge say, and I'll try to keep quiet. You know it now, right? But I'll try. All right, so the judges went on to say on 28 July 2023, the amending bill was tabled and passed in the Senate. So it was first tabled and passed. It's so fast they move. Then brought it to the House on the 25th of July 2023. Then table it the same day and then pass it the same day. No debate. Or hardly any debate, right? And then 3 days later, when it got to the Senate on the Friday, the bill amending the Constitution was tabled same day and passed the same day. So it now goes to the Governor General for his assent, and then it is gazetted, and then it becomes law. That's how the system works. So anyway, the judges reached to the point where they said that on the 28th of July, 2023, the amending bill was tabled and passed in the Senate. The amending bill was opposed by the opposition members during the debate in both houses. The jurisdiction for the bill was that the retirement ages of the DPP and the Auditor General was 5 years shorter than that of other public officers under the updated Pensions Public Service Act of 2017. You see, it was about the pension. They wanted to increase the pensionable age from 60 to 65, and it has something to do with the NIS and the fact that we are aging population, and the NIS is kind of in a trouble-ish if we have people retiring so early. So that was the motive behind all of that. Okay, so it was nothing sinister. Okay, all right, great. Let's continue. At paragraph 4, the judges stated that on the 31st of July 2023, the Governor General gave his assent and the amending bill was gazetted and given force of law. On August 15, 2023, the incumbent DPP wrote to the Chief Personnel Officer of the Public Service Commission indicating that she elected to remain in office until age 65, and this was approved, right? Because the law is now in effect. And remember, her 63rd birthday was September 21, so she had to do all of this before that time. So they approved it because they are going by what they see in the Constitution that was passed by the people in the House. Yes. At 5, aggrieved by the passing of the amending act, the respondents, aggrieved, that are Paula Llewellyn and Bunting. Aggrieved by the passing of the amending act, the respondents, Philip Paula Llewellyn and Peter Bunting, filed a claim in the Supreme Court challenging its constitutionality. The full court, after considering the issues raised before it, concluded that the amending act was validly passed and resulted in an amendment to Section 96(1) of the Constitution. In respect of Section 2(2), the full court found that the section was invalid and accordingly struck it down as being inconsistent with the supremacy clause of the Constitution. All right, so if memory serves me right, part of the challenge of the opposition was the speed to which the government had passed the law. They were saying for something that is affecting the Constitution, that's amending the Constitution, you shouldn't be able to come into the Parliament today with a bill, chat up some things and pass it today, and then by Friday it gone to the Senate and then chat up some things and then pass it, and then 2/2 it is law. So that was part of their argument as to the reason why they think that these laws were unconstitutional. You follow? Great. So let's continue. So now that the court so kindly gave us the background to the issues that were being appealed, let us now go to the conclusion, because I know that you wait for you want what the court decide. And for that, to cut it short, the court gave us its conclusions. So it says, concluding remarks, at paragraph 15, it is our determination that the full court, yes, you stop me? What? Full court? All right. Yes, I should have told you before. All this while, how much minutes you listen and you don't know what a full court is. All right, let me show you what that is before we continue. So here it says, in Jamaica, a full court is a gathering of 3 or more judges in a court that usually has 1 judge presiding. For example, the Court of Appeal, which is this case, it's also a full court. So, for example, the Court of Appeal in Jamaica usually has a panel of 3 judges, but in some cases, 5 or more judges may sit to hear a case. So that is what they mean by the full court. It's not one supposed to judge on it. Now, in the case that the Court of Appeal is speaking of, when they talk about the full court and the appeal that was coming to them from the full court, the Supreme Court, let's see if it's the same thing it means. So it says, the full court of the Supreme Court of Jamaica handles cases on a case-by-case basis, such as those involving extradition, judicial review, and constitutional matters. And they give an example. The full court may hear cases involving breaches of the Corruption Prevention Act and the Proceeds of Crime Act. In this case, because it was a constitutional matter, they were challenging an amendment to the Constitution, it would have gone to the Supreme Court's Constitutional Court to be heard by a panel now, if I remember right, of 3 judges. There were a panel of 3 judges that heard the matter, made a ruling, and now they're appealing to the Court of Appeal. And they're always a panel of 3 or more judges. You follow? Wonderful. So let us now continue. So the judges said, it is our determination that the full court was correct, that Section 2(1) of the Amending Act was validly passed. It was, however, wrong in failing to determine that Section 2(1) was applicable to the incumbent DPP. The incumbent DPP, whose tenure had been previously extended to age 63, is entitled to the benefit of the increased age for retirement by virtue of Section 2(1). There is no basis to read down Section 2(1) as not applying to the incumbent DPP. Now, you will recall that what happened in the court, the judge had said that the amendment to increase the age of the DPP from 60 to 65, that was valid. But trying to make it a retroactive act. Remember now, Paula was 63, so she done past 60 already, right? So they were trying to see if they could get her to be qualified, you understand, to retire at 65. And they did some little gymnastics. The lower court, the full court of the Supreme Court, hearing the matter, ruled that, yes, there's nothing wrong with the law changing the age from 60 to 65. But there is something funny about this business, about Paula, who had long past 60, to benefit from this. In other words, they are saying that it is another DPP who would be the beneficiary. What the court is saying, the Court of Appeal, is that the judge was right when she said that the law was valid to increase the age from 60 to 65. But what the Court of Appeal disagreed with was that it ought not to apply to Paula Llewellyn because she had done past 65 already when the law to amend the Constitution was passed. And the Court of Appeal is saying that her tenure, having been extended to 63, means that Paula Llewellyn is entitled to the benefit of the increased age for retirement by virtue of Section 2.1. So they're saying that it really don't matter. So she passed 60 already. The fact is she was still a DPP. She was still a DPP at 63, and therefore when the time was extended, it would have applied to her as well. That's what they're saying. So they said there is no basis to read down Section 2.1 as not applying to the incumbent DPP. So they went on to say at paragraph 16, concerning Section 2.2, we have determined that the full court erred in their interpretation of this section. It did not provide an option to the incumbent DPP to remain in office by circumventing the extension mechanism mandated by the Constitution and was validly passed by Parliament. Hoy, hoy, hoy! Big victory, not only for Paula, but the Parliament too. The judges in the Supreme Court, they had argued that the Constitution does not allow the incumbent to have a choice in the matter, whether she opted to. That was the kind of the wording that was used when Paula had applied for her extension to be accepted. And what the judges are saying in the Court of Appeal, that the fact that she had asked or said that she was opting for extension, they are saying that that is not a circumventing of the mechanisms by which her extension would have been granted. It seems that they're saying that the amendment to the Constitution to include Section 2.2 did not give her any option. So whether she wanted to say she opt yes or no, no matter. Yeah, you get it? I think that is what the judges are saying, that the section itself does not provide for a mechanism for the incumbent to say, all right, I opt to stay on. It simply says what the Governor General should do whenever the DPP applies for an extension of her time as a DPP. If I remember correctly, they were also seeking to apply the extension of time to the age of 65. So in future, a DPP arrives at the age of 65, and if they wanted to know, they can request an extension of time of 5 years until they reach 70. But let's read on and see what else the court said. At paragraph, the judges said, for the foregoing reasons, the following orders are made. The appeal is allowed. That is the appeal by the Attorney General. The appeal is allowed. 2, it is declared that Section 2.2 of the Constitution, amendment of Sections 96.1 and 121.1 Act 2023 is a valid constitutional amendment. 3, judgment entered for the appellant. And 4, the counter appeal is dismissed. And we will come to that in another video. But what it means is that Paulwell and Bunting, they lost their appeal, but that the Attorney General won. But let us continue reading the orders of the Court of Appeal to see exactly what it was that the Attorney General won. At 5, the court says, we affirm the decision of the full court. That means to say that they uphold it. They're not pitching it out. So we affirm the decision of the full court that Section 2.1 of the Constitution, amendment of Sections 96.1 and 121.1 Act 2023, is a valid constitutional amendment. So that gone through. Accordingly, given the failure of the full court to so declare in the proceedings below, and for the avoidance of doubt, it is declared that Section 2.1 applies to the incumbent DPP. Do remember that? After the court made the ruling, the court did not make a definitive statement that Paula Llewellyn was either in or out. And some were saying that she should go on, including the Englishman, with him bright self and meddling in our country's business. Although him are the leader of the opposition all the same. But he's not supposed to do that. So, him knows there, I run up him mouth too, and me soon bring that, because him have egg pan for him face. Right? Tell her say she should go on, because the court say, rule against her, therefore she should go on, and then she thinks that she should stay. But then, what she did, she said, all right, she'll go step aside, pending the appeal. Because if she did resign, so she'd have dead in the water. So that was what happened. So the court is saying the Supreme Court did not make an order and make it clear whether or not the section applied to Paula or not. So we're going to make it clear. Let me read it for you again, my peeps. Accordingly, given the failure of the full court to so declare in the proceedings below, and for the avoidance of doubt, we don't want to know no doubt about what we are saying. Yeah, that they must say. It is declared that Section 2.1 applies to the incumbent DPP. Costs of appeal and costs below to the appellant to be paid by the respondents and to be agreed or taxed unless the respondents within 14 days of the date of this order file and serve within submissions for a different order to be made in relation to costs. The appellant shall file written submissions in response to the respondents' submissions within 7 days of service upon them of the respondents' submissions. The court will thereafter consider and rule on the written submissions. So what is this saying? The cost of the appeal, if you hire the lawyer and all them things there, cost them money, the government, Bunting and Paula will have to go fork up some money out of them pocket. Pay for them lawyer and pay for the government lawyers too. And enough of them too, Bra. You should have seen the list of them. And a penny lawyer them either, and enough money lawyer them. So Paul, they might be looking at a 20 million or so, but them Bunting have money, man. Him can throw away a few million upon the attorney, them, not knowing of that. And in the event that they disagree with the ruling, the court is basically allowing them to appeal, kind of a way, They can come put some arguments as to why they shouldn't be paying costs or, whatever it is. They know all them legal jargon there. We're not interested in that. We're only interested if you hear the ruling. And the ruling was that Section 2.1 of the Constitution applies to Paula Llewellyn. That was the amended section. So what we are going to do before we close is go now to the section of the Constitution which is the subject of this ruling. What you said to that? Sound good? So my peeps, this was what the Parliament passed last year to amend 2 sections of the Constitution. One to do with the retirement age of the DPP and the other to do with the retirement age of the Auditor General, something that they should have did a long time, from 2017. Anyhow, so the first section now, where you hear the judge was talking about Section 2.1, this has to do with lifting the age from 60 to 65. And what they wanted, basically, they say here, Section 61 of the Constitution is amended by, and them say, no, you're going to take out the word 60, and you're going to put in the word 65. And the next section now is where it says that the period for the extension of time not exceeding 65 years, they must take that out and put in not exceeding 70 years. But the part that the opposition wanted knocked out was number 2, subsection 2. This was the part that was added in order to make it possible for the extension of time to apply to Paula Llewellyn, because by the time they seek to pass this law, fair time did pass already, because she was 63 years ago or 4 years ago. You're following? Great. So let me read it for you now. So they are saying that at subsection 2, notwithstanding, this is what is going to amend the Constitution now. This is that part that they are adding. Notwithstanding anything in subsection 1, a person who is Director of Public Prosecutions at the date of commencement of this act may, by memorandum in writing given to the Governor General, elect to retire at any time after attaining the age of 60 years. And it's the use of the word elect that the opposition had a problem with, saying that it does not accord with the section itself. It's nothing to do with what you elect, right? By using the word elect, it would suggest that she's the one that is now going to determine whether she stay on or not, whereas the law that is there now or prior to the act is saying that you apply for it to the Governor General, and the Governor General consulting with the Prime Minister and the leader of the opposition, and them are going to make the decision as to whether you stay or not. But when they use the word elect, they're saying that the Governor General can't stop her if that is what you choose to do, right? If she elect to stay on. Now, it's a matter of interpretation, and what the judge is saying, that the lower court never interpreted right, and that the amendments that are here now to extend the time from 60 to 65 does apply to Paula Llewellyn. You get it? So let me read the Constitution now as it's supposed to be read, now that the Court of Appeal has allowed the 2 sections. They said that they are valid, right? I don't know if the opposition going to go to the Privy Council with it, but for now, it's the law. Let's read. So my peeps, this is now section 96 of the Jamaica Constitution, Order in Council. And in the left margin, it says tenure of office of Director of Public Prosecutions and Acting Director of Public Prosecutions. So the sections that we are going to look at is 1 that speaks to the tenure. Now, because we don't have the benefit of the amended section to show you what it's now reading, what I underline is 60 years. Everywhere you see 60 years, I'm going to read 65. And where it says not exceeding 65 years, I'm going to say 70, so you can see what the law says now. Okay? Good. So, section 96 subsection 1 reads, subject to the provisions of subsections 4 to 7 inclusive of this section, the Director of Public Prosecutions shall hold office until he attains the age of, and it's going to now say 65 years, provided that A, he may at any time resign his office, and B, the Governor General, acting on the recommendation of the Prime Minister after consultation with the Leader of the Opposition, may permit a Director of Public Prosecutions who has attained the age of 65 years to continue in office until he has attained such later age not exceeding 70 years, as may before the Director of Public Prosecutions has attained the age of 65 years have been agreed between them. Now, this is another argument that was brought up before the full court in a constitutional challenge to the amendments, whether or not there has to be an agreement between the Prime Minister and the opposition leader, because this suggests that there needs to be an agreement. Now that the opposition leader said no, she should go on, the Prime Minister said, allow the woman, make she stay. There is no agreement, so then what happens? Well, based upon what happened before, when there was disagreement, Prime Minister said let her stay, Dr. Peter Phillips said no, let her go. what they did was to go ahead and extend her period anyway. So the Governor General does not have to take them advice. Them just need to consult with them and hear what them think about it, and then go ahead and decide what he's going to do, whether to extend the period or not. So that's the situation as it is. I may come back later. I certainly will, because me have more to tell you. Yes, man, you want to hear how Marky, the Englishman, the Marky G him. Yes, man, we cock up in the warehouse with him illegal self. You want to hear him there run off him out when the court, the court below, Supreme Court, found in their favor. Yes, me peeps, him had the loudest mouth. Anyhow, let me leave it here for now. We'll come back later with some more. Thank you so much for joining me. Remember, if you give the video a like, man. Chum, man. Give me encouragement, man. Make me feel encouraged. And of course, if you're not subscribed yet, you have reasons to subscribe now. Yes. And of course, feel free to leave your comments in the comments section and share as widely as you can. Till next time, take good care of yourselves and walk good.